This is an appeal in the matter of Navigtator Equities Ltd and another, and Deripaska, part heard.
Good morning, my lords. Yesterday afternoon, I concluded proceedings by showing your lordship certain submissions made by my learned friends in their responsive submissions as regards our additional ground 3. That was by way of a form of digression. I return to the main theme of my argument of yesterday afternoon, and that was that Mr. Deripaska and N+ faced what I described and what has been described in the evidence as an existential crisis in April 2018, and that urgent steps were required to be taken in order to save N+ from bankruptcy or Russian nationalization. And my lords, what I now wish to do is show your lordship certain paragraphs of Mr. Deripaska's unchallenged evidence on that question, so your lordships can contextualize the situation that he was in and see what the evidence was that was before his lordship below.
And when you say unchallenged, you mean it was in his, this is material, it was in his witness statement, but he wasn't cross-examined?
Exactly right, my lord. My lords, this takes us to tab 53 of the supplemental bundle.
Yeah, is that that's in the news material?
That's right, my lord, yes. This is, we had certain pages from Deripaska 5 in the prior bundle, and we took the view that it was important to see the totality. It's only 12 pages long, I should say. My lord, so we see at 386, Mr. Deripaska's fifth affidavit, which was sworn for the purposes of responding to this committal application. And my lords, I'm going to pick up the narrative, if I may, at paragraph 19, page 389, where we see Mr. Deripaska saying that under the final formulation of the Barker plan ultimately agreed, N+ will be removed from the SDN list. Your lordships will recall that is the list maintained by OFAC, the American authorities, for those who are sanctioned, in exchange for, amongst other things, my agreement to, and then your lordships will see the 3 matters referred to at 19.1, 19.2 and 19.3, giving up control of the board, reducing his ownership, indirect ownership via B Finance to a considerably lower percentage than 50%, with the voting control even lower than that, and certain behavioural undertakings. Paragraph 20, which I showed your lordship, I didn't show your lordship yesterday, I read out to your lordship, but here it is in black and white. I wish to make clear that I agreed to the above under what I described as what I regarded as severe duress, and in order to save N+ and protect the interests of hundreds of thousands of people working at N+ companies and millions of people living in Siberia and so on to the end. My lords, that was not challenged in any shape or form. Para 21 next, please. Under this duress, I agreed to have my substantial shareholding in N+ diluted, my control substantially reduced, and then he sets out the reasons why he did that in the second sentence: to preserve value for all stakeholders and creditors and protect the interests of millions of ordinary Russian people. Not challenged. My lord, we then come to paragraph 22. Inextricably linked to the Barker plan was the continuance. This is explained in more detail in Mr. McGregor's affidavit. However, in summary, 1. The prospect of redomiciling N+ to another jurisdiction had been under discussion long before the sanctions were imposed, largely driven by potential tax benefits, and there's reference to the possibility of a redomiciliation to Cyprus. This is in 2017, before the dark clouds of sanctions lowered over N+. 22.2, it was, and this is a vital paragraph, it was clear from the assistance of VTB Bank that the assistance of VTB Bank would be required in the context of the Barker plan, because it was proposed that a material part of my proposed divestment of N+ shares be achieved by a debt for equity swap with VTB as part of the refinancing of a substantial amount of VTB financing which was in default due to the sanctions. And your lordships will readily understand that any professionally drafted facility agreements will have default clauses, and the imposition of sanctions on the borrower is likely to be high up on the list of defaults. It was a core demand of VTB's participation in the transaction that N+ redomicile to Russia rather than Cyprus. And over the page, please, The continuance in the form that was put in motion and ultimately completed in July 2019 amounted to a rollover, and so on and so on. That's to the end of 22.3. I wish to now go, please, to paragraph 25. This will be of significance to other aspects of my submissions, but it is well to look at them now. 25. While I cannot recall specifically, I would say that I had come to terms with the Barker Plan and the continuance by around early to mid-May 2018, so well before these undertakings were offered or accepted at the latest, and was therefore fully supportive of them by that time. In considering the Barker Plan and the continuance and the VTB transaction as defined in paragraph 22 at this time, 1. I was focused on the commercial position and indeed the survival of N+, and whether or not supporting these proposals would be in its best interests. As noted above, I believe that the management and the board of N+ acted in accordance with best principles of corporate governance and considered both to be in the best interest of the company. As such, my representatives, acting on the board of N+, acted in accordance with my guidance, which I gave under duress to support and progress the processes required to seek to implement the Barker Plan and the continuance. And they also viewed as in the best interest of N+. And I was only asked for input on discrete issues as and when required. 2, my dispute with the Chanukin parties simply did not cross my mind in this context, unchallenged. Para 26, finally, my lords. I considered, and still do, that my decision under duress to support the Barker Plan, notwithstanding that part of it required me to cede control of N+, and the continuance, was vital to securing N+'s future as a publicly traded company and to protect the interests of millions of people. Conversely, I believe that had I not supported the Barker Plan and the continuance, doing so would have been against N+'s interest and would likely have been fatally damaging. I believe the company would have been unable to continue as a publicly traded business, and the likely outcome, given the several 100,000 people employed by N+ within Russia, would have been nationalization of the company and/or its assets and operations by the Russian government. My lords, unchallenged. Mr. Valiev, another witness, also gave evidence on that subject, my lords, and I ask your lordships to turn, please, to tab 55 and to page 412. This is the further documents. Para 17, please, of Mr. Valiev. It seemed obvious to me that the best chance of seeking to save N+ as a public company with a... can I just intercede there and just explain who Mr. Valiev was? It's page 409, paragraph 2. He served as general counsel of N+ Group between 13 and April 19, and also served on N+'s board. So a man who has particularly good qualifications to speak on these matters. You'll also see that he is a trained lawyer, and you can see that at paragraphs 1 to 3. My lord, back to para 17, please. It seemed obvious to me that the best chance of seeking to save N+ as a public company with a dual stock market listing was to get the Barker Plan agreed with OFAC. Amongst other things, if N+ remained sanctioned, it would have compromised and caused severe difficulties with export trading operations of Rusal, N+'s and Rusal's financial and banking arrangements, all sorts of other international connections of all companies within the N+ group, and both N+ and Rusal's public listings and their obligations to shareholders. Without the removal of its SDN status, it seemed to be the most likely outcome for N+ would have been either collapse or nationalisation. And your lordships can read to the end concerning, again, the same evidence concerning its role in providing power to the peoples of Siberia, where the climate is quite severe, maybe a mild understatement. My lord, that's paragraph 17. The only other paragraph I wanted to show your lordships now is paragraph 20, page 413. It also swiftly became clear that redomiciling to Russia would be a key part of securing the agreement of certain key stakeholders to the Barker Plan, including VTB. VTB would have to agree to a debt for equity swap of approximately $1 billion as part of reducing Mr. Deripaska's N+ shareholding under the Barker Plan and refinancing VTB Bank, which was in default as a result of the designation of N+, and other companies on the SDN list. VTB held significant leverage in discussions relating to the Barker Plan, and I was aware that Lord Barker personally met with VTB's management in Moscow and in London to address VTB's concern and procure its cooperation with the Barker Plan. And then this important sentence. Had VTB and other key stakeholders refused to cooperate, the Barker plan would not have been viable. My lords, Mr. Valiev, as you may recall, was not required to come to give evidence by Mr. Chinyukin. His evidence was accepted in whole, as indeed was the evidence of Mr. Makarov and Ms. Kaldina, who are other Russian witnesses who were called, or rather who gave evidence in support of Mr. Deripaska.
Sorry, I don't mean to interrupt unnecessarily, but since that page is open, could your lordships just read the first 2 lines of paragraph 23 so I don't have to go back to it?
My lords, the outcome of the Barker plan was, as hoped for, that the share price of N+ surged. N+ was saved. And my lords, for that, one need only turn to Mr. McGregor's affidavit served for this application. Tab 36, please, page 220. Where we see Mr. McGregor mentioning, this is paragraph 204.6, following the vote, that is the vote in Paris, an OFAC subsequent delisting of N+ from the SDN list on the 27th of January, public trading of N+ shares resumed, and the N+ share price shot up. And one can look at the graphic below, my lords, and see that flatlining suddenly surging on the left-hand side of the graphic.
Yeah.
The Barker plan worked, and the only way the Barker plan could work was through continuance, because VTB insisted upon it. Those are all uncontentious facts. And that therefore leads to the submission that I advanced yesterday afternoon, and which I remake very quickly and shortly indeed, which is this: that had Mr. Deripaska blocked the continuance via the vote in Paris, then the likely result on the uncontentious evidence before the court below and before this court is the insolvency or nationalisation of N+. The result for Mr. Chinyukin as the beneficiary of the undertakings offered in late June 2018, forgive me, would have been therefore catastrophic for him. And it is nothing to the point, and indeed I can't comprehend the point, that the answer that is put to that, which is we were not interested in the value of the shares, we were interested in their enforceability. That leads to this submission, my lord, which is fortified by ground 3, which I do not go back to, which is that had Mr. Deripaska blocked the vote, he would undoubtedly have been met with a committal application pitched in precisely the opposite terms. You should have voted for the continuance and therefore to save N+, and therefore to save the value of the shares.
But does this go further than sanction?
It does go further than sanction, my lord.
It can't affect the interpretation of the undertaking.
No, but what it shows, my lord, we say, and this is back to ground 3, which I'll take this as quickly as I can because I've got a lot to get through, is this, that in fact, in order to fulfill the undertakings, Mr. Deripaska could not block the vote, because had he done so, he would have faced the argument by Mr. Chinyukin that, look, you actually, by blocking the vote, by failing to vote in favour of the continuance, you have caused these undertakings to be rendered a dead letter, because the subject matter of those undertakings has lost all value, because the shares are now shares in an insolvent company. So it goes further.
That then begs the question, what is the subject matter of the undertaking, which is what Mr. Crow argues.
Well, I will come on to that. I will come on to that. But it also goes to the general question of whether it is a proper step for this court to take assuming everything else against me, to have a further hearing and a remission back in circumstances where the act said to constitute the contempt was undoubtedly and unarguably to the benefit of Mr. Chanukin.
Well, it may be that as he gave these undertakings, apparently knowing that the continuance was planned, that by giving an undertaking about certificated Jersey shares, he put himself in a position where he was damned if he did and damned if he didn't.
That may be right.
If that's so, that's his lookout, isn't it? And the only way to deal with it was to go to court and say, I've got a problem, will you help me out of it?
My lord, if he's damned if he does and damned if he doesn't, that may say something, my lord, about the propriety and the proportionality of the continued pursuit of these contempt proceedings.
Well, it gives rise to the obvious question, which I think my lord's putting to you, that if he knew about it at the time he gave the undertaking, why didn't he tell the court?
Well, my lord, there's no evidence on that.
Why didn't he tell Mr. Chanukin or that I'm giving you these certificates for Jersey shares, but you do realise, don't you, that
So will
we're
that
going to
change?
transfer it all to Russia?
Well, my lord, as I'm going to show you in a few minutes' time, Mr. Chanukin full well knew of the existence of...
Whether Mr. Chanukin
No.
knew. The fact of the matter is that these undertakings were given in lieu of a freezing injunction. And Mr. Deripaska simply didn't tell the court at the time that in fact everything was going to change.
Well, my lord, that is, I think, right, that there was no statement to Mr. Justice Robin Knowles on the
No.
18th of June. That is right.
Putting it mildly, that's most unfortunate.
Well, my lords, can I now move to, in fact, my next submission?
I mean, it'd be rather surprising if RPC knew about this. Obviously, we can't go behind privilege.
Well, RPC
It's rather surprising if they gave an undertaking about Jersey certificates, knowing that they were not going to last for very long.
Well, Lord, I was going to move to another subject, which is actually bears upon what your lordships are asking me, and it's what I described yesterday as the third unusual feature, possibly unprecedented feature of this application, which is that every step of the way, what was happening vis-a-vis or proposed to happen vis-a-vis this continuance was there in the public eye. Now, I'm going to take this very quickly indeed, because I have limited time. I'm going to give you just some references, if I may. On the 27th of April 2018, so before the application for a freezing order and 3 weeks or so after the designation of N+ and Mr. Deripaska as sanctioned persons, the board of N+ announced steps towards what became the Barker Plan. And my lords, if we look at the supplemental bundle at tab 2, we see the relevant announcement to the world. Page 10. The Barker Plan is already in place, and we see that particularly at paragraphs 5 and 6 on page 11. Series of discussions with the company's independent chairman, Mr. Lord Barker. Mr. Deripaska was agreed in principle to the proposal of reduction of shareholding, and your lordships can then read paragraph 6 as well, which is the other aspect, the other critical aspect of the plan, the resignation and the reconstitution of the board. My lords, that was the announcement on the 27th of April 2018. My lords, on the 24th of June 2018, Vedomosti, which is a Russian newspaper, published an article which said that N+ was considering registering in Russia. And the critical point for present purposes, and to touch upon a question posed by the bench a couple of minutes ago, we know for a fact that Mr. Chanukin read that article when it came out on the 24th of June. And we know that by reference to certain further information that was provided by the Chanukin parties in the context of this application. And I invite the court briefly, please, to turn to tab 41 of the bundle and to page 244. This is further information provided by the Chanukin parties in this application, as I say. And we see your lordships will see 2/3 of the way down the page a reference to little a, an article published by Venomosity on the 24th of June entitled Oleg Deripaska's N+ may register in Russia. And the article is not in
Mr. Grant, which page you on?
244, my lord. My lord, the article is not in the bundle. It might have profitably been in the bundle, but I think it was before the court, and I think I can say without fear of contradiction that it was an article which essentially discussed the fact that a proposal was being considered to migrate or redomicile N+ to Russia. We know, my lord, that Mr. Chanukin read that article at the time and forwarded it to himself by email, because that is what the Chanukin parties told us at page 245 in their responses. My lord, bottom of the page, paragraph 6.2, please. A link to Article 1, that's the article I showed you on the previous page, was sent in an email by Mr. Chanukin to himself on the 25th of June. The link was not forwarded to Clifford Chance. So Mr. Chanukin knew himself on the 25th of June that there was this proposal, hadn't been finalised, hadn't been fixed upon, but was being discussed, because Venomosity had referred to it in this article. And importantly, for the point of view of the question of context, as I'll come on to say, but I'm just dealing with the point now because it's the chronology. That was before the undertakings were accepted or offered finally and accepted by the court. They are dated, as your lordships will recall, later in June. My lords, continuing on the chronology, on the 16th of August 2018, TASS news agency, your lordships will know about TASS of course, published a report that the N+ board had approved a proposal to redomicile to Russia. That is, I'm not going to take your lordships to the bundle because I haven't got time. That is tab 18, page 107 of the supplemental bundle. On the same day, Reuters produced a news report to the same effect. N+ Group, hit by US sanctions against Russia in April, said on Thursday it was investigating the possibility of redomiciling from Jersey to one of Russia's new offshore zones. Tab 19, page 109. That's the 16th of August 2018. And your lordships, I think, have still open page 245.
Referred to on page 244.
Exactly right. Thank you, my lord. And indeed, we know for a fact, because we're told by the Chanukin parties at page 246 of the further information, that the two articles I've just mentioned, in fact, another one by Bloomberg and the Reuters article, there's a lot of coverage by leading press agencies on the 16th of August. Those articles were also read by Mr. Chanukin and were sent to Ms. Berard of Clifford Chance on the same day. This is in advance of anything substantively happening. And Ms. Berard was cross-examined on that. I don't think I need to go to the cross-examination. And she accepted, of course, there was she couldn't break privilege, that she had been sent by Mr. Chanukin those two articles, which categorically stated that there was a proposal which had been at least approved by the board for redomiciliation to Russia. And that, of course, is 3 months prior to the vote set to constitute a contempt of court. And nothing was done. No steps were taken. Clifford Chance did not write letters or bring the matter back before the court. My lords, we move further in time to the 2nd of November. There is a press release issued on the 2nd of November that the board was considering the continuance, and we have that at Mr. McGregor's affidavit, which is tab 36, page 212, please. We can look at that. Paragraph 78.1. The board of N+ had to make an initial decision that the continuance would be in the best interests of N+. in the event the decision was taken on the 1st of November and communicated to the market on the 2nd of November. And there's a cross-reference to paragraph 80. And if we go to paragraph 80, my lords, page 214 of the bundle, we can see a quotation from the relevant press announcement. To the world at large, on the 2nd of November, so 2 months before the vote, N Plus itself announces that on the 1st of November, the Board of Directors agreed measures, and your lordships can read on.
Yeah.
Now, and there was also a Reuters article on the very same day. I don't take it to the court to it. Tab 20, page 112 and 113. There was also, for what it's worth, an article in the Wall Street Journal about it, which is actually referred to by this court in its previous judgment at paragraph 16. So the proposal was being communicated to the world at large. My lords, the next thing that happened was the 30th of November, when the general meeting for the vote in Paris was convened. And we can pick that up from Mr. McGregor's affidavit, which we're still in, page 212, please, paragraph 78.3. The decision to convene a general meeting was communicated to the market on the 30th of November. So again, absolute clarity and transparency to the entire world. My lords, we know that the vote occurred in Paris on the 20th of December. That is the vote of the shareholders of N+. Again, that was the subject of public announcement. 86.2, please, of Mr. McGregor's affidavit, page 215. I'm not going to read it out, but there it is in black and white. Published to the world. And indeed, not only published, it was published not only via the RNS, but also on the websites of N+ and the London Stock Exchange, for good measure. My lord, the public notice in the Jersey Gazette on the 24th of December was in respect of N+ Group's application for continuance as a company in Russia. That's tab 23, I don't go to it, page 119 of the supplemental bundle. Again, the application, publicly announced in the Jersey Gazette, 24th of December. And for good measure, my lord, the Barker plan, the proposals to allow for the delisting from the SDN list were debated on the floor of the US Senate and Congress in January 2019. That is again the subject of evidence of Mr. McGregor. Tab 23, tab 36 again, I don't go to it, page 213. So my lords, with that very brief canter through some of the evidence, it is clear that every step of the way was published to the world. Contempts of court are, in my experience, usually perpetrated under cover of metaphorical darkness, not communicated every step of the way to the world at large. And my lords, I have made the point, and I don't make it again, other than to note that Mr. Chanukin was aware of the fact of the proposal in advance of the undertakings being offered, and did nothing about it, and did nothing about it when his lawyers became aware 2 months later in August. My lords, it is relevant to note that Mr. Chanukin did not serve an affidavit in this application, therefore could not be cross-examined on his state of mind and understandings at relevant times. The only witness who was called on behalf of the claimants was Ms. Berard, and she was the only person, therefore, who was cross-examined. My lords, when it is said by my learned friend yesterday, and he said it on a number of occasions, that the critical fact about these undertakings was that they, in some shape or form, were designed or had the effect of preventing a Jersey company becoming a Russian company, it is pertinent to ask and pertinent to draw to this court's attention, if that is so, why is it that Mr. Chanukin did nothing in June before the undertakings were offered? Why is it that he and his lawyers did nothing in August when they were undoubtedly discussing the fact of the redomiciliation because they were sending emails to each other about it. We don't know what advice was given, of course, because that is a privileged fact. And it is pertinent to ask why, given that every step of the way was broadcast to the world, and one can therefore assume that Mr. Chanukin was aware of each step, why nothing happened. If indeed it is the case, as my learned friend urges upon this court, that the purpose behind these undertakings was precisely to prevent a redomiciliation to Russia. My lords, I now turn to the fourth feature of unprecedented or unusual feature of this application, which I addressed your lordships on to a certain extent yesterday, and that is this, that on any view, this contempt, if contempt it be, and of course I dispute that vigorously, is, as things now stand post-trial, can only be, at most, what Mr. Justice Briggs described as a technical contempt. My lords, I wish to now show you the decision and the influential decision of Mr. Justice Briggs in Sectorguard. It is tab 4 of your lordship's bundle of authorities. And the facts are not of any relevance, but there are 2 paragraphs of Mr. Justice Briggs, as he then was his judgment, which have been cited many, many times since this case was decided in 2009. My lords, it is under the rubric abuse of process at page 57 of your lordship's authorities bundle, where at paragraph 44, the learned judge refers to the concept of proportionality as a concept within the new culture of the CPR. Paragraph 45, the concept of the disproportionate pursuit of pointless litigation is the subject of express quasi-legislation within the CPR. And then the critical paragraphs over the page, 46 and 47. It has long been recognised that the pursuit of committal act proceedings which leads merely to the establishment of a purely technical contempt rather than something of sufficient gravity to justify the imposition of a serious penalty may lead to the applicant having to pay the respondent's costs. Pausing there, the distinction being drawn by the learned judge is between a technical contempt on the one hand and a contempt of sufficient gravity to justify the imposition of a serious penalty on the other. Then the decision of Mr. Justice Jacob in Bimji is quoted. Since that judgment,
No,
I'm so sorry, it's the Adams case, you're quite right. Since that judgment, the CPR have come into force, that's the earlier judgment of Bimji, their emphasis on proportionality and on looking at the overall conduct of the parties emphasises the point that applications for committal should not be seen as a way of causing costs when the defendant has honestly tried to obey the court's order. 47. Committal proceedings are an appropriate way, albeit as a last resort, of seeking to obtain the compliance by a party with the court's order, including undertakings contained in orders. Pausing there. So that is, Mr. Justice Briggs, the first legitimate reason for bringing an application for committal. Then moving on, they are also an appropriate means of bringing to the court's attention serious rather than technical, still less involuntary breaches of them. So again, the distinction between serious as opposed to technical. And we know what a serious breach is. It is one that justifies the imposition of a serious penalty. And we know from a whole line of authority leading with taking us up to Keir and Watson, decided 3 years ago, Lord Justice Nugee, that a serious breach is one which will lead to is one which is a contumacious breach. Going back to the judgment, in my judgment, the court should, in the exercise of its case management powers, be astute to detect cases in which contempt proceedings are not being pursued for those legitimate ends. Indications that contempt proceedings are not so pursued include applications relating to purely technical contempt, applications not directed at the obtaining of compliance with the order in question, and applications which on the face of the documentary evidence have no prospect of success. And my lords, pausing there, when Mr. Justice Briggs says, in my judgment, the court should be astute to detect cases, That includes, I would respectfully suggest, this court, when certain facts have been established or not established in the court below. Final sentence of that paragraph. Committal proceedings of that type are properly described as an abusive process, and the court should lose no time in putting an end to them, so the parties may concentrate their time and resources on the resolution of the underlying dispute between them. Here, of course, there is no underlying dispute anymore. It's all disappeared and evaporated 4 years ago. Now, my lords, that analysis was endorsed by this court in Deripaska, in Navigator and Deripaska. And to make good that proposition, may I invite the court to pick up Supplemental Bundle, tab 44. The Lordships have looked at this already in a different context. And in particular, page 279, please. Where Lady Justice Carr, I'm so sorry, page 279, where Lady Justice Carr set out some relevant propositions of law at paragraph 82, and there are a number of them, but I don't propose to take your lordships through each one of them. But we should start at little Roman 1. The bringing of a committal application is an appropriate and legitimate means not only of seeking enforcement of an order or undertaking. Pausing there, my lords, that's of course out of question here. It's been enforced, it's all happened. But also, or alternatively, of drawing to the court's attention a serious rather than a purely technical contempt. That is the wording of Mr. Justice Briggs. Thus, a committal application can properly be brought in respect of past and irremediable breaches. And then Roman 2, again picking up language from Sector Guard. A committal application must be proportionate by reference to the gravity of the conduct alleged and brought for legitimate ends. It must not be pursued for improper collateral purpose. My lords, going over the page, paragraph 85, please, briefly, page 280. The court should be astute to detect when contempt proceedings are not being pursued for legitimate aims. There is an obvious need to guard carefully against the risk of allowing vindictive litigants to use, such proceedings improperly. It is generally not appropriate to carry, and then we don't need to worry about that. And my lords, just finally on this authority, to paragraph 112, please, page 289, where the very paragraph I've just read out from Mr. Justice Briggs is quoted at para 112. And para 114, again, Lady Justice Carr, she then was, endorses the analysis of Mr. Justice Briggs between enforcing serious rather than technical breaches. And my lords, a technical breach is one which is non-contumacious. It is the contumacy that creates the platform and the justification for a penal sanction. And for that, I draw upon a line of authority which takes us to Keir and Watson. Briefly, if we can just look at that, we can put away the supplemental bundle for the time being, go back to the authorities bundle. This is tab 11, my lord, of the authorities bundle, a very long judgment after a very long trial. Paragraph 27, please, page 322. I accept the willfulness of the breach, as counsel went on to say, vitally relevant to the question of whether to make an order for committal and to sentence. A non-contumacious breach will rarely merit a sentence of imprisonment, and a reference to a well-known decision of Lord Phillips in Gulf as of, and so on. Now, we can put away Keir and Watson and the authorities bundles now for the time being. Going back to Mr. Justice Briggs' distinction between purpose 1, enforcing an order, I made submissions on that yesterday. We're not in that territory. The purpose of the undertaking has been spent. I made submissions yesterday, I don't repeat them, on paragraph 32 of my learned friend's skeleton argument, where it was suggested by him on behalf of his clients that the purpose or the residual purpose behind the continued pursuit of this application was to keep Mr. Deripaska honest, to use the vernacular, in ongoing or future proceedings, of which there are realistically none. There are dead proceedings in Jersey, which have nothing has happened in almost 2 years, and there are certain residual costs orders which nobody's done anything about in these proceedings or in the underlying proceedings in the commercial court. It's all dead and buried, my lord. So we come on to Mr. Justice Briggs' second reason, which is to bring serious contempts to the court's attention. Now, of course, when this matter came before the Court of Appeal in 2021, that was an open question. It was being alleged by Mr. Chanukin that Mr. Deripaska had breached his undertakings contumaciously, deliberately, knowing that they were a breach. Of course, the Court of Appeal was in no position to determine that one way or the other. It was an open question to be tried out in due course. But that trial has now happened, my lords, and it is now clear that this is at best, even if my learned friend's submissions are right, the ones he made yesterday, this is at best a technical breach. I've already shown the court the background to what happened and why the continuance was fundamentally necessary to the salvation of N+. Those are unchallenged matters. But it goes much further than that, because Mr. Deripaska, in the affidavit I've shown you, in terms said, it did not cross my mind that the continuance and the steps towards the continuance could possibly have constituted a breach of the undertakings I gave in June 2018. And my lords, those propositions were unchallenged. When I say unchallenged, I'm not confining my submission to the Mr. Crowe saying, and I put it to you that is false. They were unchallenged in any proper or conceivable way. And I want to show the court what Mr. Deripaska said about that. We've looked at some paragraphs of his affidavit. I'm not going to go back to those. I've shown you ones which were unchallenged. I'm going to show you some other ones. Please, it's back to tab 53 of the further documents. It's Deripaska 5. Now, I want to show you paragraphs 13 and 14 first. Page 388, please. This is we've touched upon this without actually going to the evidence. This is the devastating consequences. Para 13 and 14, page 388. Unchallenged. And unchallenged, when I say the word unchallenged, I mean in every possible way unchallenged. Para 20 we've looked at 18, 19, 20, 21 and 22, unchallenged. All those are unchallenged. Let's go now to paragraph 31. Page 392. I am not an English lawyer. Well, let's go to 30 first. Before signing the undertaking, I read it carefully, along with the other undertakings. I treated the obligations seriously. I'm not an English lawyer, but having read the undertakings carefully, I understood the key obligation was to ensure and procure that 45.5 million shares in N+ remained available for enforcement by the Chanukin parties in the event that I failed to meet any financial liability in the proceedings within 42 days. 32. At the time I signed the undertaking, and later when the steps required for the proposed continuance to proceed were being put into effect, it did not cross my mind that the process for putting in place those steps may arguably itself have amounted to breaches of the undertaking. In particular, 1, I saw the continuation as a process that had been publicly entrained since 17. 2, I understood that no change in the status of N+ would occur until much later, and after and assuming a number of further conditions for the continuance were fulfilled. 3, I believe the continuance and the removal of N+ from the SDN list would positively enhance the value of N+ shares, and which has proven to be correct. There's no doubt about that, including all of my shares held through B Finance, which comprise both the shares held pursuant to the undertakers and a far larger number of shares in N+. 4, I understood that the shares held by B Finance in N+ would continue to exist after continuance, albeit in a Russian legal entity, and would remain marketable. That has also proven to be correct. And finally, I expected that any potential issue would have been specifically brought to my attention by those handling the continuance and all the undertakings, but it was not. That paragraph was unchallenged, and I say that in the widest sense of the term. Paragraph 40. Page 395. I certainly do not appreciate that B Finance vote might constitute a breach of the Deripaska undertaking. And to answer a question that my Lord Justice Flo and also my Lord Justice Mayles asked, I understand now that I ought to have ensured the matter was raised with the court. So that the acceptance of putting aside breach and anything else, but just in the interest of transparency, Mr. Deripaska accepted and admitted that it would have been far, far better to bring the matter back before the court. And indeed, he apologised for that, both in writing and orally in evidence. And for that apology, we see para 50, my Lord's 397.
Yeah.
And he tendered that apology directly to the court at the trial last year. But my Lord's para 40 was not in any shape or form challenged. And indeed, one might say that Mr. Deripaska was in quite good company in respect of that, given that it didn't cross Mr. Chanukin's mind, apparently. We couldn't ask him, one can only go on inference, that the redomiciliation would constitute a breach of the undertakings. It didn't cross Ms. Barard's mind, given that she knew all about it in August 2018, and yet did nothing. So he's in very good company indeed, and indeed even better company, or equally good company I should rather say. It didn't cross Mr. McGregor's mind that the vote engaged the Deripaska undertaking. And for that, my lords, we can go to tab 36, page 200. This is McGregor's affidavit for the trial. Page 218.
Yes.
Under the heading, was any contempt clear, deliberate and flagrant? And Mr. McGregor openly said, and apologised for it, I should say, that although he had sufficient material to connect the one with the other, or potentially connect with one with the other, it did not cross his mind, or he failed to appreciate that there might be any difficulty or issue. So, if it didn't cross the mind of extremely experienced and esteemed and eminent solicitors at Clifford Chance and RPC, one might be forgiven for thinking that Mr. Deripaska is not to be trudged too harshly for it failing to cross his mind either. My lord, my learned friend in answer to this point says, no, well, the test is one of fairness. And that as long as a defendant or a respondent knows that it is being said that he did something deliberately, and he's been given a fair warning of that, then the test of fairness in broad terms has been fulfilled. My lords, that is categorically, in my respectful submission, not the law.
Well, that cuts across what was said by the Supreme Court in Griffiths.
Well, thank you. I wish, if I may, I mean, maybe it's superfluous to do so, but nonetheless, I wish to take the court to what is said in Griffiths and Toohey.
I mean, either if you don't challenge somebody in cross-examination, you can't then, whether it's witness evidence or expert evidence, you can't make submissions to the effect that the evidence is not to be accepted.
My lord, that is my submission, and I respectfully agree with that. Can we just look at how the law now stands? I understand that this court is, of course, very familiar with the relevant learning, but I feel obliged to show the court what actually was said in the joint judgment of all 5 of the justices, because it simply contradicts what my learned friend's submission was.
Yeah.
My lord, we go to page 457.
Yeah.
This is of the bundle. Lord Hodge's judgment, which was joined in with by all the other members of the court, including Lord Briggs, I should say. It is the task of a judge in conducting a trial, this is 42, sorry. It is the task of a judge in conducting a trial in an adversarial system to make sure the trial is fair. It is the task of the judiciary in developing the common law and the makers of the procedurals to formulate rules and procedures to that end. One such long-established rule is set out in Phipson, quoted by Lord Justice Bean below, And then the quotation from Phipson itself. In general, a party is required to challenge in cross-examination the evidence of any witness of the opposing party if he wishes to submit to the court that the evidence should not be accepted on that point. The rule applies in civil cases. And then the reason why the rule serves an important function. If a party has decided not to cross-examine on an particular important point, he'll be in difficulty in submitting that the evidence should be rejected. Over the page, paragraph 43. I am satisfied the statement in Phipson is correct and summarises a long-standing rule of general application. Not simply a matter of the extensive legal precedents in the case law. And of course, your lordships know it goes back as long as Brown and Dunn, possibly longer.
Yeah.
It is a matter of the fairness of the legal proceedings as a whole. While many of the cases may have been concerned with challenges to the honesty of a witness, that's precisely where we are here. I see no rational basis, and then there's we're talking about other matters which go a bit further. But my lord, what is the law as then stated by the Supreme Court? It is stated at paragraph 70, my lord, page 465. Where the court lays down a number of propositions. We need to look at merely one only. The general rule in civil cases, as stated in Phipson, is that a party is required to challenge by cross-examination the evidence of any witness of the opposing party on a material point which he or she wishes to submit to the court should not be accepted. And then we might go on to Roman 2. In an adversarial system of justice, the purpose of the rule is to make sure that the trial is fair. Now, my lord, if anything, that rule applies with even greater importance and force where the civil proceeding is not sought to obtain a pecuniary remedy, but is avowedly sought, as Mr. Chanukin avowedly wishes to do even now, to have my client committed to prison. There has been no amendment to the application notice, which on its face says we will be asking the court to send Mr. Deripaska to prison. And yet, when it is known, as it is known and clear, that it is only going to be in a case of contumacious breach that prison is remotely justified, and where Mr. Deripaska has specifically adverted in his evidence to saying, it never crossed my mind that doing the continuance or taking any steps in respect to the continuance or anything I did would involve any breach of the undertakings I've given to the court. There it is in black and white in his evidence. It is not enough, as my learned friend suggests, to, as he put it, submit or ask questions that lay the groundwork to making a submission on this. That is not good enough. If a man or a woman sets out in his or her affidavit and goes into the witness box to say, I did not believe that what I did or did not do constituted a breach of the undertaking or the order, in whatever case it may be, then it is incumbent on the other party who is avowedly seeking that person's incarceration to say, that's not right. And the reason it's not right is for whatever reason, A, B, or C, and to allow that witness the opportunity to look at the judge who is hearing the case, Judge Pelling in this case, and explain themselves. And that opportunity was denied to Mr. Deripaska because nothing was put in any shape or form. And my learned friend has known about this point since November of last year. We made it very clear in our skeleton argument. The transcript of the cross-examination is available to everyone. If my learned friend had wanted to say, no, that's not right, I did put it to Mr. Deripaska, and here's the point, here's the question, or here are the series of questions which fairly fulfilled the rule in Brown and Dunn, then he had every opportunity to do so. My learned friend has declined that opportunity. The reason he's declined that opportunity is because any fair reading of the cross-examination, and I can assure this court, I have read that cross-examination on transcript more than once. Any fair reading of that reveals that the matter was not put to him in any shape or form. And therefore, it is not open to Mr. Chanukin to advance the proposition that the breaches were contumacious and therefore it is entirely superfluous and oppressive and disproportionate for my learned friend to ask, on behalf of his client, of course, or for this court to accede to a suggestion that this matter be remitted for a third time, to a third trial. It's a very important point, my lord. And while we're on the question...
Mr. Crowe yesterday, was he proposing that Mr. Deripaska be recalled so he could actually cross-examine him on this point?
Well,
Which you say, he had his chance to cross-examine him at the trial, and if he didn't do so, that's the beginning and the end of it.
I do say that, but I also want to answer your lordship's question more directly, if I may, and assist this court. Because if we go to the submissions that were served in response to my respondent's notice,
Yes.
core bundle, tab 16, page 153. This is dealt with by my learned friends at page 161. There's the rhetorical point which is said at para 27, this ground appears to have been all but abandoned. As your lordships will have seen, it's absolutely anything but abandoned. It is then said at para 27, there was ample evidence before the court to establish that any breach was indeed deliberate. The court is referred to the 7 points. Well, that's almost a concession of the point that I've made. It's not, no, the point was put to Mr. Deripaska fair and square, and it would have to be put fair and square in the circumstances of a committal application. There was evidence available. It doesn't answer the point, with respect. And then to answer my lord's question directly, we go to paragraph 28. If the court is satisfied that Deripaska's conduct did amount to a breach, it contrary to the interest of justice to be deprived of any reasoned determination as to whether the breaches were deliberate. When considering the applicable sanction, for the reasons set out in closing submissions of the court below, the appellant's primary position is there's already sufficient evidential basis to enable a court to determine that issue. If contrary to the appellant's primary submission, the court takes a different view, any further trial, and then these dark words, will be extremely narrow in scope and ought to be capable of being disposed of in its entirety. And then this, oral evidence. My learned friend didn't explain what oral evidence he was proposing or anticipating. Because the idea, given that Ms. Barad, I presume, is not proposing to come into the witness box again, one can only assume that what is being driven at there, inferentially, is by Mr. Deripaska having to subject himself to yet further cross-examination, so that Mr. Crowe or Mr. Chanukin can ask some questions they wish they'd asked first time round. The proposition only needs to be articulated to be seen as absolutely and wholly inappropriate. We've had our trial. Every opportunity was available to Mr. Chanukin to ask whatever questions he wished to of Mr. Deripaska. The questions were asked and answered. The notion that a litigant in the shape of Mr. Chanukin can say, well, I want to haul Mr. Deripaska back into the box to give him another going over, to try and extract some concessions or put some points which I didn't last time round. I mean, it's just inconceivable as a fair disposal of this appeal. Literally inconceivable. And in any event, of course, Mr. Deripaska had a right to stay silent. He didn't have to go into the witness box. As a matter for him, he chose to do so because he wished to give his evidence and wished to be heard by the court, and therefore he was subjected to cross-examination over a long period of time. In March of last year.
How long was he in the box for?
3 hours? Possibly even longer.
Giving his evidence by video link.
By video link, because and the reason for the video link was not because he couldn't be bothered to come to England, but he's a sanctioned person, so it's literally impossible for him to come to England. My lord, I wish to briefly now...
Did he give his evidence in English or
in Russian? He gave it in Russian, but there were two
simultaneous translation.
Two simultaneous translators. The view he took was, although he had given evidence in the past in England in civil cases in this jurisdiction, that given the avowed intention of Mr. Chanukin to have him committed to prison, that he wished to ensure that everything he said was precisely articulated in his mother tongue, so that he made no errors he actually articulated his evidence with precision, rather than trying to grasp for the English word, which might not have precisely encapsulated the meaning he was seeking to convey and articulate to Judge Pelling. My lords, while we're on the question of unchallenged evidence, my lord, let us just very briefly turn to the other Russian witnesses who gave evidence pertinent to this question of contumacy insofar as they could bear upon it. And just to, because a lot of these paragraphs your lordships won't have seen really before now, because Mr. Valiev's evidence was put in a very articulated way, Mr. Makarov ditto. Let's pick up Makarov first, please, very briefly, if I may. Tab 54, further documents. We've not seen Mr. Makarov before, other than tangentially. He was, you can see his qualifications and his experience and history. He was a director of M+ until June 18. He's a lawyer who has degrees from a number of eminent institutions, paragraph 3. Yeah. He gave evidence about the continuance and about a number of other matters, this gentleman Makarov. Let's just go to paragraph 12.4, page 403, please. I'm just picking this up. I don't want to jump back and forth between Makarov and Valiev at various stages. Let's just look at Makarov in the round. 12.4, I won't read it out, but I'll just invite the court to note what is said there, unchallenged. Well, this supports a number of submissions, but it does support the submission that far from Mr. Deripaska, not that it's open to my learned friend to say the point anyway, but far from, I just make it to show that I'm not trying to found myself on some particular rule of law, although I do, that far from Mr. Deripaska wishing to sort of get one over Mr. Chanukin by re-domiciling to Russia, trying to sort of shake off Mr. Chanukin, the continuance was there to save a company employing tens of thousands of people and providing the power to millions of people. It's not just some wheeze to get one over Chanukin, Mr. Chanukin, I'm so sorry. 12.4. And the business about VTB is dealt with at 13, just to drive that. I've shown your lordship 13.2, I don't need to look at that again.
Yeah.
And then I've shown your lordship 17. I don't think I've shown your lordship 17 of Makarov yet. That's the last paragraph I want to show your lordships of Makarov, over the page at 405. And again, it puts into sharp focus the supposed illegitimacy of anything that Mr. Deripaska may or may not have done.
Yeah.
So this gentleman who had a Bachelor of Laws summa cum laude from Moscow State Institute, a Master of Laws from Fordham, New York, didn't occur to him. Para 17. What hope for Mr. Deripaska, one might ask. That's Makarov. Valiev, please. We've already looked at this gentleman, and I've shown you who he is. Page 409. We've looked at para 17 earlier this morning. We've looked at paragraph 20. Let's briefly look at paragraph 18 finally. Yeah. None of that was challenged. And then finally, Ms. Caldina, who is a lawyer to Mr. Deripaska. She's in a different file, or rather a different part of the file, tab 38, please, of the supplemental bundle. Again, another very well qualified person. Paragraph 3, she's worked in the offices of Steptoe and Johnson and Squire Sanders, LLM at Emory University, qualified in Russia as long ago as 1985, so a person of immense experience. And for relevant purposes, can we look at paragraph 27, page 228, please? Again, if your court will allow me, I won't read it out. Just invite the court to read it.
28.
So sorry, paragraph 27, page 228.
Thank you.
even when she was making this affidavit, after the application had been made in November 2019 to commit my client to prison, even with all her experience and understanding, she still couldn't actually understand how it could be said that the undertakings were breached. Now, of course, it's a matter for the English court to determine that question, not for Ms. Caldina. But it says something about Mr. Deripaska's state of mind, if even Ms. Caldina couldn't understand. From her Russian perspective, it may be said. But Mr. Deripaska is also a Russian man. He doesn't have a degree in law from an English university or anything like that. So that's the only things I wanted to show the court as regards those matters. And that leads me, after a relatively long canter through a number of pieces of evidence and submissions, to the submission I started off with yesterday afternoon, which is that this application, for all those reasons, if it wasn't oppressive in 2021, and I'm not in any way going behind the Court of Appeal's judgment, has now become oppressive, abusive, and disproportionate. It has to be stopped now. The notion that this goes back to Judge Pelling, and it could only realistically be Judge Pelling, if you're otherwise against me, for a third trial, is an outcome that just simply cannot be contemplated in the context of fairness, proportionality, and oppression. My Lord, I'm going to move on now to a new subject and a new submission. I wish to now address your lordships on the question of cancellation. And my learned friend's case on that. Now, the judge below set out some propositions of law in paragraph 31 of his judgment. Can we very briefly turn those up? None of them will be of any surprise to this court, of course, but just to see the way that Judge Pelling went about his judicial task. He set out at paragraph 31, core bundle, tab 6, page 57, certain principles that he was going to apply. And the 9th principle, forgive me, the 10th principle is set out at page 59. The applicant is confined strictly and solely to attempting to prove the contempt application set out in the application notice, and the court is confined to considering only those allegations. And for that, he cited Lord Justice Voss, as he then was, his decision in Re L, the decision of, and the judgment of Mrs. Justice Tice, and the decision of Mr. Lord Justice Nugee and Kieran Watson, which we've already looked at in a different context. And I won't read out, if I may, the quotation from Lord Justice Nugee. Now, in my learned friend's skeleton argument, they say that the propositions at paragraph 31 are common ground. So paragraph Roman 10 is, as I apprehend it, common ground. It couldn't be gainsaid in any event, in any serious way. So that is the task that any court considering a committal application has to set themselves, and they have to study the application notice, and they have to ask, has that application, and have the propositions of fact which are laid out in the application notice been proven to the criminal standard. Now, although my learned friends say we agree all that in their skeleton argument, and Judge Pelling got the law entirely right in paragraph 31, in reality, their case below and their case on appeal involves a radical disapplication of the principles at Roman 10. Any fair reading of their skeleton argument reveals that in fact what they say the court should do, both this court and the court below, is that the way you go about trying a committal application is you pick up the undertaking or the order, you then look at all the evidence that has been presented, and starting with a blank piece of paper, you carry out some kind of inquisitorial inquiry or roving commission to work out whether a breach is discernible or not discernible by the task of comparing the one document, the undertaking or order, with all the evidence that has been addressed. And of course, that is completely wrong. In our system, in the adversarial system, the burden is on the claimant or the applicant to plead with precision, especially so in a committal application, precisely what it is said the respondent has done or not done, such as to put them in breach of the order or undertaking. And of course, as Lady Justice Carr, then was said in Navigator, a heightened standard of procedural fairness is required in a committal application because of the consequences for the respondent. Now, the flaw in the presentation below and this appeal is evident from my learned friend's skeleton argument. And can we now look at that skeleton argument? I don't know if it's open, if your lordships have it open, or whether it's in the core bundle. But if it's in the core bundle, it is core bundle tab 3. I have mine as a freestanding document, and it is paragraph 44, which I believe is page 35 of the core bundle. Now, after a long run up to the wicket, so to speak, my learned friends start properly their submissions at para 44. Page 18 of the internal pagination. And what they say there is, with respect to the judge, both his approach and his conclusion was wrong. And then this, the issue before the court was whether Mr. Deripaska had acted in breach of the undertakings. In order to decide that issue, the court had to interpret the true meaning and effect of the undertakings properly understood in their relevant context. And we then have 4 or 5 pages of submissions up to paragraph 52. In fact, not 4 or 5, 3 pages of submissions up to paragraph 52, top of page 21 of the internal pagination, explaining why they say the court was wrong and why the court should have made a finding of contempt. It is notable, and I ask this court to consider this carefully with respect. There is not one mention in any of those paragraphs, and indeed there's not one mention in the skeleton argument as a whole, of the contempts alleged to have been committed by my client as put in the application notice. I think
you say that in the second sentence of paragraph 44, the appellants have mischaracterised the issue.
we do.
The issue was not whether Mr. Deripaska had issued in breach of the undertakings. The issue was, had he done what was alleged in the application notice?
Exactly right. Exactly right. And it was a remarkable feature, we thought, on this side of the court, of this skeleton argument, which is that sets out my learned friend's case, that the application notice, I stand to be corrected, it may be briefly glanced at, is not mentioned once in the totality of the skeleton argument. Certainly the breaches alleged to have been perpetrated are not addressed. The charge sheet is not gone through. Instead, my learned friends start from the proverbial piece of paper, blank piece of paper, and say, let's look at whether or not Mr. Deripaska committed a breach or not, as if one was doing so from a tabula rasa. And we say, with respect, that that is one of the fundamental flaws of this appeal. There are many others, of course, and I'm going to come on to those. But one of the fundamental flaws of this appeal is that it starts from the wrong premise. Now, of course, my learned friend, no doubt cognizant of the difficulty that his skeleton argument and the whole approach placed his client in, then endeavoured yesterday to go back to the application notice to try and extract from it and try and make good that it had been, indeed, the charges set out in it had been made good. He tried his best with that, with the greatest respect to Mr. Crowe, and of course said it with great eloquence, as he always does. but one could detect the discomfiture of actually trying to place the case as made out and presented and for which permission was granted in the skeleton argument and fit it in to the square hole or the round hole, depending on where you look at it, of the application notice. My lords, in brief on this subject, the court has to, we say, when considering any contempt application, has to intensely and narrowly focus, without deviation, on the matters alleged in the application notice and ask, have they been proven and have each of them been proven to the criminal standard? And any fair reading of my learned friend's skeleton argument reveals that that task is entirely abrogated and shaken off. And there is an obvious forensic reason for my learned friend simply deciding to just cast off the application notice like an unnecessary appendage, cast it off because they know they can't make good their application as it was pleaded in the application notice. And of course, I don't need to go back to what was said by Lord Justice Nugent in Keir or Lord Justice Voss in Re L. Those are matters well known to the court and are apparently uncontentious before this court at the bar. And I should say I make no apology for making those submissions. They are not pleading points. Emphatically, they are not pleading points. They are points which have been laid out by judges of high authority over many, many years, and in fact endorsed by the CPR, where the CPR says...
In one sense they are pleading points, but they're pleading points in relation to contempt application,
my lord,
which has to be satisfied to a criminal standard. And the one thing you can't do is to engage in effectively a wide-ranging roam around
quite right.
The facts of the case.
Well, on your lordship's formulation, they could be described in one sense as a pleading point, but they are obviously that without the pejorative connotation that might be said to flow with it.
Well,
So you say that the pleading point is an aspect of the procedural fairness which these applications require?
I do, absolutely I do. And I'm going to look at this application notice with some care.
well, it's in a sense, it's a point which, going back to pleading points, Mr. Grant, I mean, if you look at cases of fraud, for example,
Quite.
then quite often you have pleading points in relation to cases of fraud, which are entirely appropriate and proper because of the seriousness of the allegations that are made.
And I believe, with respect, that some of the constitution of this bench have made some very plangent comments on that in judgments in the past.
I
Quite
think
right.
what Mr. Crowe is trying to get at is that the application notice does allege what Mr. Deripaska is supposed to have done. It also alleges, wrongly as it turns out, the legal consequence of what he did. And I think that Mr. Crowe is trying to distinguish between making the allegation that this is what you did, which was a breach, and this is the effect of what you did, which is, so to speak, subordinate.
Well, we're going to come on to that, my lord. I can assure your lordship that I'm not going to shy away from that proposition. In fact, because I say it's fundamentally wrong. We're going to look at that with some care. Now, my lord...
He also, as I understood it, in his oral submissions, as it were, took on board the word cancellation in the application notice, but made a submission that that did not refer to what he characterised as it were, the company law aspect of cancelling the shares, but had to be interpreted more in the light of what he said was the subject matter of the undertaking.
Well, I'm going to come to that as well, my lord.
Okay.
I'm absolutely going to come to that. My lord, the way that this applicant came before Judge Pelling's court with that wrong conception, and fundamentally wrong conception, is nowhere better revealed than in their skeleton argument for trial, which my learned friend showed you some paragraphs of, which is the further documents, paragraph 67. Sorry, that's not a helpful citation. The further documents tab 57, where we see at page 430 the skeleton argument for trial.
Yeah. And
then under the heading at page 454, cancellation of the Jersey shares, we see, and it's a paragraph which I'm going to invite the court to read quite carefully, paragraph 67. My learned friend showed you para 66. I'm now looking at 67. Since that letter was written, pausing there, that is the letter of the 29th of May 2019, which contained what Mr. Justice Andrew Baker rightly described as some errant comments, which I'd certainly disassociate myself with and have been disassociated for the last 4 years, 3.5 years. Since that letter was written, that's the RPC letter, Mr. Deripaska's legal team has devoted considerable energy to arguing that the redom was in the commercial interests of N+'s shareholders, we've already dealt with that, and that notwithstanding the redom, 1, N+ continued to exist, 2, the shareholders, including B Finance, continued to hold shares in N+, 3, B Finance continued to be bound by its undertakings not to dispose of or deal with those shares in N+. See Mr. Gregor's second witness statement, paragraph 75. Just pausing there, just while we're on McGregor 75. I'm sure your lordships will not have picked this up yet, but McGregor put in a witness statement before the hearing before Mr. Justice Tier in July 19, and he put in that, and that was a witness statement dated the 28th of June 2019. And can we just very briefly turn para 75 up, just to see what was being said on behalf of Mr. Deripaska in June 19.
So, which bundle?
Supplemental tab 14, please.
So should we keep 15?
If it's possible to keep them both open, my lords, that would be. Yeah. Sorry, I'm looking at the wrong. I'm looking at the citation, my learned friend's skeleton argument. In fact, it is supplemental bundle tab. Forgive me, I've got it. Tab 30.
Tab 30.
Yes, please. Sorry. Sadly, you don't have the actual front page because of a certain stringency taken on in relation to page numbers for the court. This is McGregor's witness statement of the 28th of June. So before the hearing before Mr. Justice Tier, where there were 2 applications on both sides. And at paragraph 75, page 141, he said this. This is 6 months before the committal application was launched. For the avoidance of doubt, the undertakings given by Mr. Deripaska and B Finance are affected only in part by the continuance, while the parts of the undertakings relating to the share certificates, and of course there were no undertakings given by Mr. Deripaska in respect to the share certificates, as I'll come on to show, will not be workable post-continuance because the share certificates held by RPC will be cancelled. The other obligations related to the shares in N+ are drafted broadly enough to still cover the shares in the new Russian entity post-continuance.
Could you just read on? Because
I'm going to. Don't worry.
confused.
I'm very keen to read on. Even though the continuance was not, as far as I'm aware, anticipated at the time the undertakings were entered into, which is of course wrong, as we now know because of what Vedomosty say. As such, Mr. Deripaska and B Finance remain bound by the obligation not to deal with the undertaking shares unless and until the undertakings are lifted. This ought to give the Chinookan parties comfort that the status quo will remain until at least the hearing of this application. So it was being accepted on behalf of Mr. Deripaska as early as June 2019 that the undertakings remained alive and kicking, and as regards Deripaska's undertaking, completely alive and kicking, as regards the shares in the Russian entity, because they were the same shares. Now, that was a little digression. Going back to my learned friend's skeleton argument, back in the further documents at tab 57, page 454. Having set out all the things that Mr. Deripaska's legal team had devoted considerable energy to arguing, it is then said on behalf of Mr. Chinookan, however, in the context of this contempt application, that line of argument is entirely irrelevant. So apparently the fact that N+ remained in existence post-redomiciliation, didn't suddenly dissolve itself and reconstitute itself a new company, the fact that the shareholders continued to hold the shares, the fact that the B Finance continued to be bound by its undertakings, apparently is entirely irrelevant now. The question for this court is not whether after the redom N+ remained in existence as the same legal entity, just note that, my lords, when we come to the application notice, or whether the shareholders continued to hold shares in it, or whether their shares were worth more or less. That's all irrelevant, apparently. The applicants were not shareholders in N+, they were creditors of Deripaska. In that capacity, their only interest was in the availability of assets for enforcement. That is what the undertakings were designed to protect. As I will demonstrate, I hope, that case, that's apparently the heart of the case, as put before the judge. I still don't quite understand what is being said there, but what I do understand, and what I do suggest, is that nothing of that nature is anywhere remotely articulated in the application notice that I came before Judge Pelling to answer on behalf of my client. And my lord, we can put away my learned friend's skeleton argument before the trial. We can go back to their skeleton argument on appeal, because we can see the extent to which they are running away from their pleaded case. When we pick up their skeleton argument, tab 3, I think your lordships may have it in, internal page 2, paragraph 6, where, and this perhaps is the summation of their case, paragraph 6.
Hang on a second.
Forgive me.
Tab 3.
I think my learned friend's skeleton argument is at tab 3 of the core Bible. So it's page 19 of the external pagination. This might be said to be the heart of the matter from my learned friend's point of view. The fundamental error which the judge made was to ignore or misconstrue the meaning of the shares in the context of the undertaking and focus instead on the question of whether the shares were, and then that little word, technically cancelled. Now, and the word cancelled in quotation marks, as if, well, the word cancellation, let's not worry about that, let's ignore that word. Let's get to the heart of the matter as we now treat it as, which is a matter which, as I've said, involves not actually looking at or mentioning the dread words application notice in the totality of my learned friend's skeleton argument. And what essentially is being conceded there is we didn't make out our case as pleaded, and we're trying to resurrect or erect a new case, which is divorced from the application notice. And it's my submission, as your lordships know, that that is a fundamentally heretical and inapposite thing to do. The matter can be taken a little further as to what they're trying to do on this appeal, and indeed what they were trying to do before Judge Pelling. By looking at para 46 of my learned friend's skeleton argument, page 19 of the internal pagination. For the purpose of interpreting the undertakings and deciding whether Mr. Deripaska was in breach, the question, one, whether N+ is the same legal entity as N+ Jersey, N+ Russia is the same legal entity as N+ Jersey, and two, whether under Jersey law and or Russian law the shareholders are deemed to have the same or equivalent rights, are irrelevant. Now, I would suggest that any fair or reasonable reader of the application notice, having read that application notice and then alighting on paragraph 46, would think, well, hang on, what's going on here? Apparently matters which are at the heart of your application notice are now irrelevant. And let's read on. So I don't want to be seen to be distorting my learned friend's argument. What mattered for the purpose of the undertakings, and hence for the purpose of any alleged breach, was not the notional rights which the holder of any shares had in an N+ company, but the claimant's ability to enforce the sale of the certificated shares through the mechanism of the undertakings. Just note that, my lords, but the claimant's ability to enforce the sale of the certificated shares through the mechanism of the undertakings. We're going to look at the application notice in a second, but let's look at it in the context of this case as is now presented. I can't pretend to actually understand the case even now, having heard my learned friend's eloquent submissions, but that apparently is the case.
Well, the criticism they make is articulated at the beginning of paragraph 45.
Yes.
And if one leaves aside the adjectives and adverbs. Question is whether the claimants did raise a point of company law as to whether the shares could be described as cancelled. If that's what the application notice means, then that's the case they're confined to. If the application notice means something wider, then that's the case.
Well, my lord, again, I'm very grateful to your lordship for going to paragraph 45. One sees again the word cancel put in quotation marks, or inverted commas rather, and technically, again, there's an attempt to evade, I would say, the plain meaning of the application notice, which I'm now going to come to. Let's turn it up, please. It's tab 9 of the core bundle. Now, starting with, it's paragraph 80, it's page 87. One noticed just in passing that the time estimate for the hearing of this application was put at 5 hours at paragraph 87, 4.5 years later. It starts at 90, part C, page 90.
It took 3 days before Judge Pelling.
It did.
2 days before us.
And I think there were 2.5 days or so of argument before Mr. Justice Andrew Baker. The paragraph 9, page 90, my lord, is the start of the application notice proper. We see at paragraph 1 the avowed intent to seek an order for committal to prison. Paragraph 1, never been resiled from. There's then some narrative, which I don't think we need to trouble ourselves with. We then go to the only reference to Jersey law, I should say, is at paragraph 19. And that's only in the context of what majority was required for a vote by the shareholders of N+ to redomicile.
Yes.
That's the only reference to Jersey law, no reference whatsoever to Russian law. We then get to paragraph 22, bottom of page 94, which my learned friend showed you yesterday. By reason of the matter set out above, Mr. Deripaska has breached the undertakings and is in contempt of court as follows. So everything that follows are the ingredients, so Mr. Chanukin says, of his committal application and are the ingredients of my client's alleged contempt. Nothing is superfluous. It's not they've just chucked in a few allegations randomly for good measure. This is the foundation and basis for my client's contempt. Little a, your lordships have seen that, the special resolution to approve the continuance, the vote in Paris. B, the procuration of the vote and the allegation that it was determinative of whether the continuance would take place. Now, my lords, this is a convenient moment for me to just digress briefly, so as we don't have to go back to little b in a separate section of my submissions, to the question of determinative. Now, your lordships are aware that one of my respondent notice points is that the claimants did not prove, and the judge did not find, and in fact he could not have properly found, that the continuance, that the vote was indeed determinative of the continuance. But that is a necessary ingredient of bringing home this contempt allegation against my client. Now, the reason the judge didn't decide the question was because he didn't need to decide the question based on the decisions he made. But I raise it by way of respondent's notice, and I propose now digressively to deal with that question now. Now, the word determinative, I hardly need tell this court, but having looked at the dictionaries, I find that the dictionary writers tell us that the word means a factor or circumstance that settles or determines something. That'll come as no surprise to the bench, of course. Now, that is what the claimants set out to prove, and that is what they had to prove. Now, did they prove, or could they possibly have proven? Certainly the judge made no finding in their favour on the question, and they don't, by way of a further aspect of their appeal, seek an order from this court. I mean, it's in one sense a remarkable situation that we find ourselves in. They had to prove determinativeness. They do not, by way of their appellant's notice, say, and by the way, the the judge below should also have made a finding of determinativeness for reasons A, B and C. So on that basis, one could say that their appeal is fatally flawed and that my respondent's notice is entirely superfluous. But I want to go further than that, because I want to show to your lordships that there was no possibility of the judge finding that the vote was determinative of the continuance. And my lord, that involves me picking up, inviting lordships to go back to Mr. Valiev's affidavit, please. Back in the further documents. Back to tab 55, please.
Yes.
Where Mr. Valiev says all sorts of things about all sorts of important matters, and none of which was challenged, as I've mentioned. But at paragraph 24, page 414, he sets out all the steps that had to be taken in order for the continuance to actually take place. Now we can pick, I'm not going to take very long on this, but I will invite your lordships to read this in full, this paragraph. 24.5 refers to the general meeting that occurred on the 20th, and that was undoubtedly a condition precedent to the continuance. If the vote had not passed with the relevant majority, then it would have stopped it in its tracks. But there was then a series of steps that had to be taken after that vote, which are articulated at 24.6 through to 24.12, which are, on any fair reading of that affidavit, and indeed any fair reading of the facts as they were disclosed, are entirely independent and separate steps, in the sense that the vote does not presuppose the happening of the remaining steps. It is not like the domino is flicked and they just, all the other dominoes fall to their inevitable end. These are, we have the 21-day period at 24.6, and then crucially at 24.7, the new independent board of N+, installed on the 27th of January 19, as part of the Barker Plan, as part of the terms on which the sanctions were to be lifted by the US Congress and Senate in the terms of their approval. What had to happen was a new board, entirely independent of Mr. Deripaska, made up of new individuals, had to agree, and not only agree, approve the continuance. And your lordship will see a reference to the TOR there. That's a document which was signed by N+ and OFAC. The terms of removal. It was a binding agreement as to the basis on which the sanctions were to be lifted. And one of them was, as said by Mr. Valiev, the new board. And the new board voted indeed in favour of the continuance, but they weren't bound to do so, and the vote in December did not presuppose them having to do so. It was an entirely freestanding vote taken by the board based on their perception of what was in the best interests of the company as they perceived it to be when they took the vote on the 18th of April 2019. So that's point one. And then we have the point raised by the bench by, I think, possibly my Lord Justice Lewison yesterday, the fact that there is a statutory obligation on the part of the JFSC to approve or not approve. And that's a discretion vested in the JFSC. And my learned friend was asked, well, what are the criteria and how do they exercise that discretion and by what reference to what standards or criteria? And my learned friend wasn't able to answer your question, and I'm not able to answer your question. But I'm not the one who's having to prove the case. But in any event, it doesn't matter. What matters is that they had a discretion which no one suggests was determined or predetermined by a vote in Paris by the shareholders. And then a whole host of other things in Russia, which I can leave the court to consider in their own time. But on the question of the discretion, what we do have is a letter from the JFSC in the supplemental bundle, which casts some light on the question.
Yeah.
Which is tab 33, my lords, of the supplemental bundle. It's a short one-page letter dated August 2019. And this is tab 33, sorry. And what Mr. Lamb, the Registrar of Companies of Jersey, says at tab 33, he deals with the question about the Viscount holding the shares pursuant to some orders made by the Jersey court. and then says this in paragraph 4, Article 127U of the Companies Act or law provides the JFSC with a discretion as to whether or not to grant a continuance application, even if the statutory criteria have otherwise been satisfied. And then your lordships can look at the last paragraph, which are bespoke to a particular scenario. So what is clear from that letter, and indeed clear from 127U, which sets out the statutory obligation on the part of the JFC to either withhold or not withhold consent, is that that is a freestanding independent hurdle or
But it's clear from the last paragraph that as matters then stood, his provisional view at least was that he wouldn't approve
exactly.
the continuance.
I mean, as things
So
happened, it
it's
all
described as some sort of rubber stamping
No.
exercise.
precisely right. But so that I don't want to, so that your lordships have the actual text of the law, it's page 501 of the same further documents bundle. It's the last page. This is 127U of the Jersey law.
Yeah.
If on an application under this is 127U little 1, if on an application under Article 127T to the Commission, it is satisfied of various matters, the application fee has been paid, the Commission may grant the application on the conditions specified in para 2 or on such other conditions, if any, as it may specify in its decision. So on the face of it, it is an untrammelled discretion.
Yeah.
Right, that's 127U, and 127T is in another part of the bundle. So your lordships do have that as well. So knowing, and that was all uncontested. So how does my learned friend's client prove that the one was determinative of the other? Well, my learned friend says, well, but for X, it wouldn't have happened. My lords, the but-for test and the test of determinatives are entirely separate legal beasts, with the greatest respect. The but-for test has nothing to say whatsoever about a test of one thing being determinative of the happening of another. And the poverty of Mr. Chanukin's case on this can be revealed, my lord, if we spend 4 minutes looking at their skeleton argument below. Your lordships may think, well, why are we having to go over the old ground of what was argued below? The reason for doing so is that in my learned friend's own submissions on this appeal, they say the point raised in the respondent's notice is bad, and it's bad for the reasons set out in our skeleton argument below. So I'm driven back to that skeleton argument below to see what in fact is said there. And my lord, let's just look at it, because it only needs to be looked at with the greatest respect, to be seen as just legally misconceived with huge respect. My lord, tab 57 is the skeleton argument.
Yeah.
Paragraph 30 we are asked to look at first. Page 441. As is clear from the above extracts, once a relevant breach has been identified, there's no further requirement that such a breach must be causative of loss. Mr. Deripaska has previously argued that causation concepts in tort and contract should be imported into the law of contempt. That's wrong. And so on and so on. I've no idea what paragraph 30 has got to do with this point. The claimants have said the vote was determinative of the continuance. That is part of their fundamental case at paragraph 22. And here we have submissions about what's causation got to do with contempt applications. It's just totally beside the point. And then we are told to go to paragraph 59 to 65. 452. One of the arguments raised previously by Mr. Deripaska was that the B-Finance vote, the one in Paris, 20th of December, did not cause the redom on the basis there are various other stages that need to be implemented before the redom completed. It is the applicant's position that Deripaska's argument is unfounded for the reasons outlined in para 30. Well, those are completely, with the greatest respect, inept reasons for the purposes of this particular aspect of the claim. In any event, there is a requirement to demonstrate that B-Finance vote was the dominant cause insofar as, no, Mr. Chanukin, no, determinative. That's your pleaded case. That had to be your pleaded case. That's the question you have to prove. Right, 61. Deripaska's support was essential to passing the shareholder vote. How does that assist in any shape or form? Assuming it's right, how does that assist in any way, shape or form? It doesn't. Second, 62, it was a necessary precondition. So what? Even if that's right, so what? Tells us nothing about whether it was determinative. And then 63 refers to what McGregor had to say and says there are two answers, 64 and 65. Let's very briefly look at those. Although subsequent events after the shareholder vote might have intervened to prevent the read-on, now, just pause there. Although subsequent events after the shareholder vote might have intervened to prevent the read-on, an entirely false statement about what actually the process was, as Mr. Valiev says in unchallenged evidence. And then this analogy, which is a totally false analogy. If a contract's been broken and loss has been caused, the contract breaker cannot say he didn't cause the loss simply by showing that some third party might have intervened. But it's got nothing to do with third parties intervening to stop. It's not like the bowling ball has been unleashed and is careering towards the 10 pins. And the fact that somebody might have thrown themselves onto the rink to stop the ball reaching the 10 pins, therefore it's not caused. How is that in any shape or form a relevant analogy where there are accepted to be freestanding things that have to happen wholly independently of the vote for the continuance to take place? We can just strike that through with respect. And then 65, in any event of the 12 stages identified by McGregor, McGregor had done the same thing as Valiev. I didn't need to show you McGregor because Valiev does it just as well. The fifth consisted of the shareholder vote, and then this, other stages consisted of the absence of objectors being raised, or various, pause there, my lords, or various administrative or clerical matters. Well, how is the vote of an independent board instituted by OFAC obligation, independent of Mr. Deripaska, how is that a, quotes, administrative or clerical matter? How is a decision, a discretionary decision vested in the JFSC, an administrative matter? My lords, the claimants have no answer to this question. It is fundamental to their committal application. They cannot prove it, not just to the criminal standard, which is what they have to any standard. It's obvious they cannot prove it. That alone requires this application to be dismissed. My lords, that's my digression on determinativeness. I go back, please, to the application notice itself. We're back to tab 9, page 94 of the core bundle. That's little b. We've looked at little c. The effect of the continuance was that the shares of N plus secured pursuant to the undertakings and defined therein as the shares would be automatically cancelled. And that's a quotation from McGregor's witness statement, we're told, which is quoted at paragraph 20. So they're using the word automatically cancelled in some way which is analogous to the way that Mr. McGregor has used it. Now, Mr. McGregor had got that wrong, as it turns out, and we certainly don't accept for a moment that they were, quotes, automatically cancelled. But that's the thing they set out to prove, and they get no benefit at all from the fact that Mr. McGregor 5 years ago put in a witness statement which proved to be wrong and which we did not in any way uphold as correct. And then this. The other thing they have to prove at little c1, in a new Russian domiciled company. Now, we have seen already that my learned friends in their skeleton argument below said it doesn't matter whether the company remained the same. This is paragraph 67 of their skeleton argument. It doesn't matter. It's all hot air. It's just noise. What matters is some ability to enforce something through the mechanism. No. That's what they set out to prove. They have to prove that the company in Russia was a, quotes, new Russian domiciled company. And my lords, so we can understand this is precisely what their case was, we need only go back very briefly to the Court of Appeal judgment back in 2001, 2012, 21 rather, tab 44, if your lordships can pick up 44, keep the core bundle open if that's convenient. Back to the judgment of the Court of Appeal, and it's tab 44, and let's go briefly, please, to
Yeah.
paragraph 68, page 274. Just so we can see, I'm not trying to ascribe some technical meaning to what the pleading says. This is under the heading, the appellant's position. Lady Justice Carr says this: the overarching submission for the appellants, that's the Chinookan parties, is that the judge's conclusions, that Mr. Justice Andrew Baker, were premised on a fundamental misunderstanding of the consequence of Deripaska's actions. The conduct of which the appellants complained was that Deripaska either assisted in procuring or at the very least failed to prevent, and then this, the dissolution of N+ Jersey and the incorporation of N+ Russia. And the protection, I'm so sorry, as a result, Mr. Deripaska's shares in N+ were cancelled because of the dissolution of N+ Jersey. And so the case that was being put to the Court of Appeal, which can only be a case founded on the application notice, there's no other case, was that N+ Jersey was dissolved and a new company, N+ Russia, was incorporated.
Well, I think that that's made quite clear by what Lady Justice Carr said about the errors that Mr. Justice Andrew Baker made. His error, so she said, was to assume it was common ground that the shares still existed.
Well, we now know it is common ground because paragraph 67 of the skeleton argument below made it clear that it was entirely irrelevant and that what really mattered was some mechanism of enforcement. So we go back to the, your lordship's right, of course, with respect. We go back to page 95. We know what the Chinookan parties are saying. They are saying that the Russian company was a new one. And that, of course, is not some superfluous plea. What they're saying is, you owned shares indirectly in Company 1, the Jersey company. We had an undertaking, we had the benefit of undertaking respect to those shares. And what this continuance has done, capital C, is it's dissolved those shares and dissolved that company so that they've been obliterated, those shares. And we've now got a new company in Russia to which the undertakings don't apply. Now, if that was factually proven, one could well understand why Mr. Chinookan might have had the beginnings of a complaint. But of course, that wasn't factually proven. In fact, it was resiled from. No case whatsoever to that effect was maintained. And it wasn't maintained, my lord, because looking at the evidence of the act, insofar as one could discern anything, looking at the evidence of the Jersey law and the Russian law, in fact, there was a seamless, one might say the clue is in the word, continuation from Jersey to Russia. And Judge Pelling went some way in his judgment to analysing the Russian law and the Jersey law. And he did that without prejudice to his primary conclusion, which was that given that the claimants had decided not to call any evidence whatsoever, then they hadn't proven their case. But he said, well, look, if I'm wrong on that, let me not just be too chary about it. I'll look at the law. And he then looked at it very carefully and quoted a very large number of provisions within the Russian IC law, which had been approved by the Duma in July 2018, and said it's, on the face of it, in fact, it looks like pretty clearly that the company didn't lose its stop having status A or stop existing. The company remained the same. The shares were not destroyed or cancelled. And my lord, it's quite apparent, in my respectful submission, that the word cancelled is being used at sea in the way that the ordinary reader would understand it to mean, which is destroyed, stopped existing. Not on my learned friend's new characterization, lost certain characteristics and gained certain different characteristics. Maybe my conception of the English language is imperfect, but any reasonable reader of those words would conclude looking at C1 in the round, that what is being alleged is that shares stopped existing.
And I think you also say, don't you, that because the words automatically cancelled appear in inverted commas and italics as a quotation from Mr. McGregor, the meaning of those words in paragraph 22C must be the same meaning as that to which Mr. McGregor ascribed to them in his
Yes, quite.
in the witness statement.
Right, because what is being I'm sorry to interrupt if I'm interrupting my lord, but because what effectively the claimants are saying is, well, you've set out some evidence about what's happened. We're seizing on that evidence, we're holding you to it. Now, of course, there are no admissions. The law of contempt doesn't allow for estoppels, and certainly none is established or proven or alleged even. It doesn't allow for admissions in the way that one has formal admissions and permission or applications to resolve from admissions in the CPI, the normal source of civil litigation. And no one suggested that. But my lord is right. And it's driven home by in a new Russian domiciled company. That's how they're being cancelled. Not because they had a particular characteristic which is now changed, which is now my learned friend's new case. My lords, we then go to little 2, where a distinction is clearly drawn by the pleader between shares and share certificates. Again, the phrase in a new Russian domiciled company are referred to. But when we go to D, as we now do, we see the 3 alleged breaches alleged. And we see that there are 2 interesting features about those breaches. Feature A is the whole question of share certificates is not raised at all. There is no allegation of breach as against Mr. Deripaska founded on the cancellation of the share certificates. And that there's been a clear distinction between share certificates and shares made by the pleader in C1 and Roman 2. And that's for no doubt good reason, because the Deripaska undertaking had nothing to do with share certificates, didn't mention the RPC undertaking. It cross-refers only to the B Finance undertaking. That's interesting feature 1, the absence of any reference to the share certificates. The other interesting, well, I put it too low, critical feature, is that the cancellation of the shares caused by allegedly caused by the vote, we know about that, we've already looked at that at little b of 22, is at the heart of each of the breaches alleged. My learned friend yesterday attempted to put forward a new case which said that our breaches are entirely independent of the cancellation of the shares. Now, how can that be a fair reading, I asked the court, of breaches 1, 2 and 3, especially in the light of paragraph 22, 1, 2 and A, B and C? It's absolutely clear in my respectful submission that the heart of this committal application and is the cancellation of the shares. And that's why Judge Pelling, quite correctly, said that if that wasn't proven, then the case fell to the ground.
Well, there are 2 elements, aren't there, of the breaches. One is the cancellation, which you say didn't happen in the sense in which that word is used in the application notice.
Yes.
And the other element is it's that the vote caused the cancellation.
Quite, in the sense used at B.
To your point about determinative.
Exactly right. Well, my lord is as ever ahead of me, but there are in fact a number of other things that in respect of each breach has to be proven, which I'm going to spend just a tiny little bit of time looking at now, my lord, if it's convenient. But your lordship's absolutely right. We're just looking at breach 1. Effectively 4 things had to be proven to the criminal standards for Mr. Chanukin to carry home breach 1, count 1 as I should say it. Thing 1 was that the cancellation of the shares had occurred. Thing 2 was it was caused by B Finance is an affirmative vote. I've already made submissions on that. Thing 2 was that it was procured by Mr. Deripaska, and I'm going to make some submissions presently on that. And that was thing 3 rather. And thing 4 was that the vote amounted to a dealing or disposal. Now, I'm going to come back to cancellation in a little more detail in due course. I've dealt with the causation question. Let me digressively deal with procuration, because your lordships raised it with my learned friend, and we have raised it on our respondent's notice. And the point is this, that Mr. Judge Pelling below emphatically and expressly did not make a finding on procuration because he felt he didn't need to. We say, by way of further support of the order that was made by Judge Pelling, that as regards at least breach 1 and breach 2, procuration was necessary to be proven. Now, the reason I say that, my lords, is because when the pleaders, after the Court of Appeal went back to look at their pleading and to think whether it could be improved, and they did that in February 2022, so sometime after the judgment of the Court of Appeal had been handed down, they put in some amendments, and we can see some amendments on that page 95. They said at little d, by procuring and or permitting, and then they carried that through not to count 1 or count 2 for very good reasons, because of course those are counts dependent on a positive step being taken by Mr. Deripaska. As regards breach 3, which is not dependent on a positive step being made by Deripaska, they then inserted the words as procured and or permitted by Mr. Deripaska. So what is clear and quite understandable is that they had to prove, to carry home this contempt as regards breach 1 and breach 2, an act of procuration. Now, I don't think there was any dispute whatsoever that the procuration, if there was any proven, would have to be post the undertakings. No one suggested the undertakings had some sort of retrospective force. So what had to be proven for count 1 and count 2, quite apart from all the other things that had to be proven, was that to the criminal standard that Mr. Deripaska had procured the vote in Paris. Now, Mr. Deripaska gave evidence about that. And this requires us, please, to go back to the further documents and back to Mr. Deripaska's affidavit, which is tab 53.
Yeah.
And we've looked at it, but not in this precise context. And this is why I need to look at it in this precise context for a very short window of time, please.
Yeah.
He said this at 25.1, page 391. I'd come to terms with the Barker plan and the continuance by around early to mid-May, so well before the undertakings, at the latest, and therefore was fully supportive of them by that time. He doesn't dispute that he was supportive of the continuance. In considering the Barker plan and the continuance at this time, I was focused on the commercial position and indeed the survival of N+, and if I can invite your lordships to read on to the end of para 25.1. And in fact, he gave evidence before Judge Pelling that he hadn't actually spoken to Mr. Wyszynski, who was the sole director of B Finance, for 10 years. And then, so he gave his general guidance back in May that he wanted to promote these things. Then at 37.1, 37.2, forgive me, under the rubric and heading the vote on the 20th of December 2018, whilst I was not consulted by Mr. Valiev at the time before he provided that confirmation, I did not, and that's the confirmation at 37.1, which your lordship should read as well. I haven't got time to look at it in detail now, but one needs to look at 37 in the round. Wasn't consulted by Valiev at the time before he provided the confirmation to Wyszynski. I do not dispute that it and B Finance vote were in accordance with my general guidance, and that Valiev had the authority to give the recommendation to Wyszynski. Valiev had known since as long ago as May 18 at the latest that I supported the Barker plan. Now, what does Valiev have to say about this? Very briefly, same bundle of further documents, tab 55. It's paragraphs 30 to 33, page 416 to 417. And again, I'm not going to read it out. I would invite the court just to read 30 to 33 to themselves, if that's convenient, where he gives evidence about the circumstances of the vote in Paris. So, undoubtedly, Mr. Deripaska had said in the early days of the sanctioned status, his sanctioned status and N plus sanctioned status, that yes, he wanted and was keen to ensure that steps were taken to free N plus from its sanctioned status, and that involved subscribing to the Barker Plan and therefore necessarily the continuance. There was no evidence that he had specifically said to anyone after the undertakings were given, vote in this way. I require you, or I would like you, whatever word anyone wants to use, to the man who actually voted, which is Wisniewski, to vote in this way. And the judge made no finding to that effect because he took the view he didn't need to. Now, that creates fatal problems, alongside the other fatal problems, I should say, for count 1 and count 2, because there is no appeal in respect of that. By way of appellant's notice, Mr. Chanukin does not say, and I, for the reasons A, B, and C, this court must insert a finding or make a finding to the criminal standard of procuration so I can carry home breach 1 and 2. They say nothing at all about it. So in one sense, my responder's notice is superfluous on that question. But I don't want to leave it like that. I want to go further and show your lordships that the evidence wasn't there. If they can't prove procuration, counts 1 and counts 2, for those reasons alone, disappear. That's all I wanted to say about procuration.
What does procure indirectly in the undertaking mean?
Well, I don't know. It's not my language, my lord. I just don't know. My learned friends have not elaborated that.
I follow your point that the judge has made no finding and there's no appeal against the lack of a finding. But you went on to say, well, there's no evidence. But we do know, do we not, that Mr. Deripaska's authorised representatives voted in favour. And might that not be indirect procuration?
Well, the procuration has to occur post the undertaking.
Yes.
Has to occur. So an actual physical step needs to be proven post the undertaking. To procure something requires... I'm so sorry, I interrupted.
If I authorise my agent to do something and he does it after the undertaking, why isn't that...
Well, the act of procuration...
My act, regarded in law as my act.
The act, undoubtedly, if one was to expand the window of time to the authorisation given in May, let's say, then that was an act of procuration in May, just authorising something to be done in general terms. But here, the undertakings were given in late June. So the question for the pleader and for Mr. Chanukin was to prove that Deripaska had taken an affirmative and actual step post-June to cause the vote to occur on the 20th.
If there is a pre-existing authority to do something, the exercise of that authority is not procuration by the principal. There may be a failure to revoke the authority,
yes,
but that would come under breach 3.
Exactly right.
Yeah.
Permitting, or rather than procuring.
Yeah.
Exactly.
So there would need to be a reauthorization, you say, after the giving of the undertaking, which could then be said to be a procuration or an indirect procuration of the vote.
Yes, that's exactly what I say. My lords,
Precisely because breaches 1 and 2 are dependent on, I think elsewhere they're described as a positive undertakings.
Yes.
Taking a step.
well, they're breaches of the negative undertaking, and in order to breach the negative undertaking, you have to do a positive step.
Taking a step involves something happening, something having happened after the undertakings were given.
Exactly right. Exactly that and one.
And you say, well, nothing happened after the undertakings were given.
on the evidence that the court had, and there is no.
And if something happened before the undertakings were given, as my lord's just put to you, that might or might not be permitting something in the sense of breach 3, but you
Yes.
didn't establish breaches 1 or 2.
That's why I'm confining my submission here to breaches 1 and 2.
Are you going to come on to breach 3?
Breach 3 carries with its own
Yeah.
special problems. But my lord, just to drive that point home, your lordship quite rightly alighted upon the language which commences 1 and 2,
Yeah.
took a step which had the effect of, and then dot, and then
Yeah.
dot. My lords, so we have. I am going to look at breaches 1, 2, and 3 in various other ways, because there are various other things and various other problems with them. But let me now deal a little more with the question of quotes cancellation. I mean, I've already dealt with it in some detail, but I want to say a few more words about it. Now, it's common ground that there was no Russian or Jersey law before the court, and Judge Pelling had cause to comment on that, and took the view that by reference to the decision in Brownlee and certain dicta of Lord Legate, that although Lord Legate had opened the possibility that there might be some cases where the law is so clear, the foreign law is so clear that it didn't require expert evidence, that was not this case for a number of reasons, not least because we were in a penal territory. And there's no suggestion that he was wrong on that, and no appeal against that chain of reasoning. So what the court, what is now being said, as I understand it by my learned friends, is not that in fact there was sufficient evidence of foreign law on the documents themselves to carry home the appeal, the committal application, or that one could read into the Russian law or the Jersey law and discern really what it's all about, and it's clear that a cancellation took place. What in fact my learned friends say is that it was a complete red herring. Expert evidence utterly unnecessary. It's got nothing to do with what the law of Russia or the law of Jersey says. It's all about the characteristics of the shares having changed their status in particular ways. So we say
There is no challenge to the the judge's findings of foreign law.
No.
That as a matter of the company law of Jersey and Russia, the shares were not cancelled.
there's no such finding. There's no such challenge. Quite right. In fact, my learned friends simply sidestep the question and say it was all entirely irrelevant what the foreign law says. It's all entirely irrelevant what Jersey law says, and as a result, they say nothing at all in their appellant's notice or in their skeleton argument about what the Russian law and the Jersey law meant and how it can be contiguously read together. That was the task that Judge Pelling, with conspicuous diligence, if I may say so, set himself to look at. De bene esse, because he'd already made a finding that without the expert evidence the case found him. He said, well, I'm going to still look at it, and did look at it, and looked at it with some degree of care, and took the view, as my Lord Justice Males says.
Right.
Now, so there was no foreign evidence, but let me say this now. Foreign law evidence. Let me say this. It might be said, looking at Lord Justice Nugie's decision in Keir, that well, you shouldn't just confine yourself to the application notice. You should also look at the evidence that is served and required to be served in support of the application notice, and that's Ms. Berard's 8th affidavit. And perhaps my learned friends can seek some succour from that affidavit. I say that would be impermissible. It has to be within the four walls of the application notice. But against myself, let's say, well, perhaps Ms. Berard put the matter in a different way. Well, let's look at Ms. Berard for a second, because in fact, on analysis, well, not just on analysis, on a first blush and a last blush, Ms. Berard's, it is quite clear from Berard 8 that she embraced with gusto, on behalf of her client, of course, the proposition that was advanced quite clearly in the application notice that this was an application, a committal founded upon the extinction, the destruction, the cancellation of the shares. Tab 35, supplemental bundle, please.
Well, you can see it from paragraph 4.
Well, as ever, my lord is ahead of me.
Tab 34, 35.
Tab 35, page 165. Thereby-
Erasing their existence and value.
Well, I mean, it couldn't be clearer. Not that the claimants really, on analysis, could take succour from some different way of putting it. But I don't want to be seen to be just confining myself to the application issue, although that's what's required.
And then she also goes to the RPC letter.
She does. She goes to the RPs, and in fact, on analysis, the entire case, as presented in Barrard 8, is based on, well, look what RPC said. Job done. Case over. But except the RPC letter was wrong.
Yeah, she says it again at paragraph 77.
I'm looking at my speaking notes, and para 77 was
Yeah.
there. You're stealing my thunder, my lord. But can I go a little further on that? Para 69.
Yes.
So lest it be thought that, oh well, the application notice is not to be read in too meticulous a way. No. When Mr. Deripaska comes to read this affidavit to work out what has it said I've done to justify my incarceration into one of Her Majesty's, as it then was, prisons, he reads at para 69, deliberate and serious breaches particularised in paragraph 22 of Part C, which I have seen in draft. So Mr. Deripaska, as the reasonable reader, thinks, well, therefore the case I have to mount, the defence I have to mount, is to paragraph 22. That's where it's at. And lest there be any further doubt about it, para 73, this is page 190, by
It's
causing
actually
B Finance to vote.
32 in its unamended form, so only references to procuring, not permitting.
Yes, but I of course
That
accept that
doesn't
there was an
matter
amendment. I'm not
necessarily.
taking a point on the
No,
amendment.
but if one's looking at the evidence taken with the appellant's notice, and I follow your point, the application notice, follow your point, you don't do that, you shouldn't do that, but even if you did, she's only addressing procuring.
Quite. And then, my lord, if we go to 73,
Yeah.
again, cause the redomicile and the consequent destruction of the N plus shares. And my lord, as I listened to my learned friend yesterday making his submissions, I thought, my gosh, we've come a long way from the application I thought I was coming to meet before Judge Pelling last year. Consequent destruction of the N plus shares. I'm going to come to some of my learned friend's submissions he gave yesterday, because they are a country mile, if I can use the old phrase, from the application that was pleaded, that was evidenced, and which I came to meet on behalf of my client before Judge Pelling in March of last year. And I think those are all we need to look at from Ms. Barrard's affidavit. Now, we've looked at
Your
the...
point about paragraph 73 is that it's not suggesting that the mischief is the conversion of a Jersey registered company into a Russian registered company, being the same company with a new domicile. What she's saying is that the EN plus shares were destroyed.
Exactly.
Not simply EN Jersey shares were destroyed, but the EN plus shares were destroyed.
Quite. My lord has it in one, puts it quite correctly. And in fact, my lord, what I was going to then say, and I'm going to say very briefly, that if one looks fairly and in a straightforward way, in a reasonable way, at the application notice and the evidence served in support of it. Of course, Mr. Deripaska will no doubt seek advice from his English lawyers to work out what to do. His English lawyers say, well, that's the case we have to meet. We must advance evidence and submissions to meet that case. And that's what they would do. They no doubt did. But one then says, by reference to my learned friend's submissions yesterday, well, where does one find in either the application notice or the draft order, or indeed Barrard 8, if we're allowed to look at it, which we're not, but let's do so de bene esse, where does one see the new case my learned friend now advances to this court, such as, let's just go through some of the submissions he made, that the real rub and mischief of the undertakings was to mean that my client didn't need to enforce against assets in Russia. Not Russia, as my learned friend said yesterday. Nowhere. Nowhere. Where does one read that it was vital that this company remained a Jersey company and no other company? And that was fundamental to the undertakings. Nowhere. Where does one read? We don't give a monkey's about, we don't care about the shares continuing or the company continuing or everything going on as normal. What we care about is the ability to enforce. A phrase I still don't quite comprehend, no doubt it's an imperfection in my own faculties. No, but nowhere. It's a complete surprise to both Mr. Deripaska and his lawyers. But while we are in Berard, let me just, so that I don't have to look at Berard anymore, let us just go forward to a submission also advanced by my learned friend yesterday, which is that, the undertakings have to be read in the context of the archaeology of the negotiations. It's my word, the archaeology, and I don't resile from it. One assumes one would have seen in the application notice, if it was to be said that the undertakings had a special meaning or a particular contextual meaning and were breached by reference to that contextual meaning, one assumes that that would have been fairly and squarely in accordance with the general rule that the respondent must know the case he or she has to meet with precision, so that would have been laid out in the application notice. Words to the effect of, it was fundamental to the undertakings and they should be read by reference to the proposition that the shares had to be Jersey shares, but no other share, no other jurisdiction. The shares had to be certificated shares and not dematerialized, and therefore implicit within the undertakings, as indeed this has to be the claimant's case, there is to be discerned somehow or other, there is a negative obligation not to redomicile the company. Now, I should tell you immediately that I don't accept for a second that the undertakings bear that meaning or can properly bear that meaning, and that certainly wasn't the case that I prepared to meet last year. But one would expect that to be in the application notice. My lords, I'm not going to take you back there and perform some performative exercise of going through them and saying it's not there. I can assure your lordships, and your lordships have no doubt read the application, not one suggestion is articulated in the application notice that that's the true gravamen of the undertaking and the true gravamen of this application notice. But again, taking an expansive view of these things and not wishing to found myself on the application notice itself, does one find it in Ms. Berard's affidavit, one asks? Does one see in Ms. Berard's affidavit, look, I want to make very clear so that Mr. Deripaska knows precisely the case he has to meet, that what we're actually saying is that these undertakings have to be read by reference to letter A and letter B, and my learned friend spent about half an hour going through various letters sent between the solicitors in May and June of last year, to say, well, that's therefore you can craft and read into these undertakings this point and that point. Does one find that in Berard's affidavit? Answer, no. There is not one hint in Berard's affidavit of the point that, well, if you look at that letter, and I want to quote that letter, and I want to quote this letter, taking it all together, look at the skeleton arguments, that therefore one can read into the undertakings all the points my learned friend has sought to extract from them. There is not one suggestion of that. As my Lord Justice Lewison put it, the foundation of the, or may have put it, I don't want to put words into his mouth, the foundation of the breach is simple. You've put in a letter saying the shares were cancelled, ergo you breached your undertakings. It's as simple as that. And are there any references to the correspondence at all? Well, I think there are. Page 175, to give Mr. Chanukin his due, there is a page 175, a reference to the letter written by Clifford Chance on the 19th of April. but it's not suggested to be relevant to the interpretation of the undertaking. It's just simply say that's the letter that founded what became the application for a freezing order. Then there's a letter of it's fair to say there's a letter on the 8th of June, referred to, Clifford Chance, page 177. But that's to do with an inconsistency in the position being taken as to control of shares or control of companies, nothing to do with interpretation or indeed breach. So the Barrard affidavit, and of course, I'm so sorry, let me repeat that, let's restart that submission. Your Lordships know that under the CPR, whether in the previous incarnation or the subsequent incarnation when the rules were changed, all the evidence relied upon by the claimant has to be contained within the affidavit served supportive of the application notice. All the evidence. Here, as regards my learned friend's contextual submission, none of the evidence was contained, or virtually none of the evidence was contained in the affidavit. So that's all I wanted to say about Ms. Barrard's affidavit.
Well, whatever's meant by the overall context of an undertaking, looking at what I said in Pan Petroleum and also Abliazov
Yes.
in the Supreme Court, it doesn't mean you can have resort to, as it were, pre-undertaking negotiations in correspondence. In much the same way as none of that's admissible in construction of a contract, because what the parties are negotiating about at an earlier stage may or may not be reflected in what eventually goes into the undertaking, and what one party eventually agrees is the basis for lifting the worldwide freezer.
My Lord has it entirely with the greatest respect. I listened somewhat aghast, I have to say, to my learned friend's excursus into the prehistory of the undertakings.
Where they all may not have got what they wanted, as it were, and may have decided to, putting it metaphorically, cut their losses and take what was being offered.
Well,
and that may or may not have corresponded with what they wanted in the first place.
My Lord, thank you. And I completely, with respect, agree and associate myself with that. In the next 4 minutes, can I just make a few brief submissions on the question of context? My Lord, I found myself on your Lordship's judgment in Pan Petroleum, and indeed cited it before Judge Pelling. I think Judge Pelling himself cited it in his judgment. The idea that a person who gives an undertaking to a court has to then, when it comes to working out, well, what does the undertaking require me to do or not to do, then has to have a kind of file of correspondence to leaf through to think, crikey, I better go back to what Clifford Chance said a month earlier, just to make sure I'm not somehow contravening something that they said which could somehow be read into the undertaking. I mean, it's a recipe for disaster and unfairness. My learned friend put it in this way in his submissions yesterday, and I quote page 25 of the transcript. So reference is made there to a collection of evidential pieces, and if the correspondence demonstrates what the concerns were of my client at the time, and they are concerns that are communicated to Mr. Deripaska, and Mr. Deripaska is offering undertakings in order to meet those concerns, then that correspondence in my submission, evidence of what the purpose of the undertakings ultimately was, because it is evidence of the function that the undertakings were intended to fulfill, that the risk my client felt existed about an inability or great difficulty enforcing in Russia. Now, it may be that the transcriber, for perfectly understandable reasons, hasn't precisely, because there's some infelicities in language, which of course would not be associated with my learned friend, but one got the drift and the gist of what was being said by my learned friend. He said at one point, and he varied in this point. On the one hand, he said concerns of Chanukin. Then he at page 31 used the phrase objectively verifiable concerns. Both propositions are highly problematic. The expression of a concern itself, this is a concern entirely devoid of any kind of rationality, does that nonetheless, because it's been articulated before an undertaking has been given, does it nonetheless, do you have to read into the undertaking some recognition of that concern? Okay, well let's go on to my own friend's new formulation, objectively verifiable concerns. Well, that gives rise to its own problems, because then when coming to construe the undertaking, if a committal application is then issued, then apparently on that basis the judge has to undertake, the judge trying the case, has to undertake a prior inquiry as to whether the concerns articulated in the correspondence leading up to the undertaking were, quotes, objectively verifiable or not. I mean, one's in, to use, if I may, a legal cliche, we're in Alice's Wonderland at that moment. That's the kind of task that a committal judge should set him or herself. And of course, the other difficulty is that if my learned friend's right, it creates huge problems for defendants offering undertakings. Do they have to specifically say in their correspondence before that, I should say that in reading this undertaking, in interpreting this undertaking, we have to discount the following correspondence, because otherwise they're at risk of the kind of investigation and inquiry my learned friend invited the court to do.
There is some authority about this, actually. I think it's a decision of Mr. Justice Munby in a family case. I think one of the parties may have been called Harris.
Harris and Harris. It's cited in Keir and Watson.
Yeah, essentially saying that undertakings need to be self-contained.
Quite right. In fact, your lordship is, as ever, got the point, and of course your lordship's learning in this area is well known. But the Harris and Harris is cited in Keir. As it happens, I cited it.
Well, if we need to look at it, we can look at it.
Yeah, it's still there, and exactly what.
Should we break then, please, Mr.
Thank you, man.
Court rise.
2 o'clock.
Court rise, if able.